Good evening, ladies and gentlemen. As our practice here every Thursday, we bring you our fourth episode of the LegTech Dialogues. But before we do the official opening, this time around we have a visitor who is going to do an opener for us with respect to the current technologies that are affecting research in universities, African solutions that are providing research tools that are customized for our African problems. You and me know that today young men and women are using ChatGPT, others are using Gemini, others are using all kinds of research tools. The question is, are these tools customized for our settings? The answer is no. And therefore, we have invited an innovator who is going to use 15 minutes to take us through some of the recent African tools that can help students in research, that can help lecturers in research without necessarily the artificial intelligence hallucinating. My friend Paul normally says that the problem is hallucination, and if you don't know, hallucination is where artificial intelligence, the tool you are using, once it fails to find information it needs, it goes and finds jurisdiction in another area. Let me take this opportunity to invite my friend Austin. Austin is the director of LegTech, a local company here, to do the presentation. Over to you, Austin.
Thank you. Hello. Good. Okay, thank you. My name is Austin. So, speak this way. So, I'm a developer at LegTech, and I've built a platform, an AI-powered solution that I believe will greatly transform legal practice. And I'll quickly go to show you how it works. So, allow me to start. I'm allowed to. I'm not reading my screen. Yeah. Yeah. Yeah, you can. Not yet. Mirai. Okay, thank you. Allow me to set right. I believe you can see. So this is Sharia. Sharia in Swahili means law. So we fused artificial intelligence and law. We've inculcated Ugandan case laws into the platform, laws, and every other relevant material that you may want for your practice. So I'll quickly show you what the first feature that we do have. We have case laws. We've incorporated all case laws from ULI into the platform and synthesize it. So you can actually filter by judges. You can be able to see all judges in the platform. You can make filter by topics. You'll be able to see all the topics that you do have. And unlike ULI here, you can actually synthesize as per the topic. So I'll want to go, for instance, on rent restriction. I can say open this case of, I want a good case. I can, these are very old cases. I want quite foreign case. I want new cases. Let me look on trespass, for instance. I'll be able to see all cases on that particular topic. And I can open one, Board of Governors. The case of Board of Governors, Stroke Directors, Caltech Academy, Makerere, and another versus Luwede Kasule. So in this particular case, I can brush through. So unlike typical legal tools, like Yuli, for instance, you'll have to read through the case to get to synthesize the has not yet read. It hasn't read my laptop yet. I'll check. You're having a problem with the projector. Okay, fine. It's working now. So in this particular case, for instance, Jalia Naiga versus Isa Sekabira, I can be able to view the issues, the legal principles. System is. Are you reading it? I'm having problems. Yeah, it's my laptop. Okay. So. Let me look at this one, for instance. It's okay now. So here I can be able to see for instance, I can brush through the legal issues emanating in the case. I can be able to see the legal principles. Unlike initially, you have to read the whole case to find these particular points. But here, you can brush through. You can see the legal principles emanating. You can look at the arguments by the parties. You can look at the ratio. The suit is barred by limitation because the cause of action as played by the plaintiff arose in 1999 when the defendants allegedly began interfering with the plaintiff enjoyment of the land. You could see the outcome of the case. So the suit was dismissed as it was barred by limitation. You can see that the plaintiff was rejected and suit dismissed with cost to the defendant. You could look at the case details. You can see the citation. The court is the High Court of Uganda. You can see it's a ruling on preliminary objection. You could even see the parties of the case, the plaintiff, the defendant. And now the beauty here is we wanted to cure hallucination. There's been an issue whereby people say AI is giving misleading citation. But with this platform, you can actually view the case in Yuli. So you'll just click on the link and it will take you to the case as it is. So you can see this was the case and this was the decision outlined. So you can be able to harmonize, you can be able to marry the citation given and the case with this particular platform. Now I want to go to something else that is interesting. You can actually chat with the case. So instead of reading a whole judgment, you can actually chat and make inquiry to the case. For example, I'll want to ask what are the key legal principles established in this case. So I'll click on it and it will run through the database and provide me the key legal principles outlined. So it's generating. So you can see it will tell you the governing rules, section 5 for the Limitation Act. No action for recovery of land shall be brought after 12 years from the date the right to action accrued. You can see section 25 of the Limitation Act. If an exception like fraud is to be relied on to extend limitation, it must be expressly and specifically pleaded by the plaintiff, including the circumstances justifying the exception. So you can be able to see all this. You can see the judicial interpretation. So the court relied on some case laws. There's a case of Iga versus Makerere University, 1972 case. A plaintiff by limitation is barred by law and must be rejected. There's a case of Nabisire Geraldine Mirundi, where the court affirmed that limitation statutes automatically extinguish the right to litigate after the set period, irrespective of merit. So you can be able to chat. I can be able to go further and ask, for instance, provide, say, 4 similar cases. So it will run through the database and provide me 4 similar cases on the topic. So these are the 4 similar cases on the topic. There's a case of Kisibo versus Baube and another. The court dismissed a suit for recovery of land as time barred, holding that Section 5 of the Limitation Act imposes strict 12-year period. The plaintiff failed to plead any exception to such fraud. There's a case of Kaseta versus another. There's a case of Bwambale versus that one. There's a case of Barungi versus Kasozi. And the beauty here is that you can actually click on the case. So I can click on Kasibo case, for instance. When I click on it, it will open up. There's Kasibo versus Baube and another. Again, I can see the issues emanating in the case. I can see the legal principles. No action for recovery of land shall be brought after the expiration of 12 years. I could see the legal arguments. So you can be able to marry. So the issue with hallucination is actually defeated in this particular instance. Now, we also have the home button where you can actually ask anything in relation to for research purposes. So I've prepared a set of questions. For instance, I'll want to ask this question. I want to ask, say, on this particular case I have here. So I have this case I want to ask. So does the doctrine of separation of powers hold effectively in Uganda, given the constitutional authority of the executive over the judiciary and the legislature? So I can tell you to rely also on case laws when answering. So I've posed that constitutional question. It will run through. So the question is, does the doctrine of separation of powers effectively in Uganda, given the constitutional authority of the executive or the judiciary and legislature? And I want you to rely on case laws. It's giving me affirmative no. It's saying that while the doctrine of separation of powers is recognized in Uganda legal framework and case law, its effectiveness is frequently compromised in practice, especially due to executive encroachment on the judiciary and the legislature. So it's giving the governing rules, and there are case laws to that effect. There's a case of Murangira versus AG, where the Constitutional Court declared Parliament interference with court judgment and its purported exercise of judicial authority unconstitutional, reaffirming that the Parliament cannot usurp judiciary role. There's a case of Bob Kasongo versus AG, where it was held that judicial authority cannot hold executive office, and any such dual office holding is void as it undermines judicial independence and constitutional separation. Again, you can actually marry and confirm if indeed the case laws exist. I'll click, for instance, on Bob Kasongo case. When I click on it, it will take me again to Bob's case. I can again brush through the issues, the legal principles, and everything. So in addition to that, you've got the upload feature, where you can actually upload a document. It could be a plaint, it could be a query, it could be anything that you want to ask. You can actually upload and query it in the platform. I could ask, for instance, I can upload this case law. I have this case. I'm looking for a good case to ask. Just a minute. Yeah, I can have this case. I could ask it to provide me summary of the judgment. Quickly, it will run through the platform and it will give me a summary. Now, what I'm trying to say is, now that we've got as dons, I'm Kenyan, I'm from Kenya. We have seen a trend recently of Kenya universities adopting artificial intelligence as a unit, as a course, especially for in schools like Strathmore and Kabrak. So because the new lawyer that is coming up is going to be very different. He's not going to be research oriented as you guys. So you need to appreciate that particular change that is coming forth. So you've had instances whereby we are marrying, I know universities have got learning portal. We are actually marrying them with artificial intelligence so you have a learning portal, we marry it with AI, and that fee is a charge on students. So students pay an extra fee on an AI powered platform, enabled platform to that effect. So we have got all their notes, their materials synchronized into AI so that they can actually assist them to do general revision and etc. So with that, I beg to stop. Thank you so much. Thank you.
Wow. We're good. Wow. much. My friend Austin. Austin works with a local tech company here called LexTech that is providing solutions. Ladies and gentlemen, now this brings us to our official opening. This conversation is that as they are using so our curriculum is a tradition. So you find there is a mismatch, and that's why we want to have this conversation today. And it's our humble prayer that today fight which are to join and conversation to National Council for Education and Council, so that we are standing with the innovations that are taking place. For us in the legal practice, in private practice as lawyers, we are finding challenges, and not until we have these schools of distance, schools of this nature, that the young men use these tools, but have they been taught how to use these tools? The young because same essay because they used all of them the same ChatGPT. But the question is, how do we solve that problem? The students are saying, what should we use? And the lecturers are quiet because they also don't know what's the way forward. And that's why we think this conversation is really very, very important. Ladies, now let me take the pleasure to introduce to you the district team here, district premier top law universities in the country that has way forward on how best we can be able to re-engineer legal education for the new digital era. We are going to run this session for strictly 2 hours, and we are going to have an equal time for each of the deans to first make a presentation to us on what is happening, on what they are adopting, what they are doing in their institutions as guided by the host. Ladies and gentlemen, let me take this opportunity to invite a small Christine Kisubi. Dr. Esther Christine Kisubi is the School of Law at Kampala National University. She holds a PhD in law administration focusing on environmental justice in the oil and gas sector in Uganda. So rose from a senior lecturer of research in the Kampala International School of Law to emphasizing technical collaboration. She has been instrumental in fostering partnerships in the Service Commission, work and multi-court competitions. Beyond that, Dr. Kisubi resonates with Uganda's development. To talk about Kisubi in 2 hours. Ladies and gentlemen, permit me distinguished speaker. That is Professor Dr. Shadat Semakula Mohammed, if he's in the room. I think he's still finding his way here. To have Muchibi come last as a regulator, LDC, to the pair as introduce you Paul Muchibi. You have been following is a legal academia, a researcher and an advocate, a law reform expert and digital rights activist with over 70 of legal education. And that's why sometimes some of us in doctor because he's doing a doctor student, PhD student, I don't know. He holds a master's in higher education management and administration. Law and human rights with a CGPA of 4.5. Young men, I hope now you know. Ladies and gentlemen, Mr. Muchibi has lectured at the Uganda Law Development Center, Makerere University. He has lectured at UMY. He has lectured at Uganda Christian University. He has lectured at IUI University. He has lectured at Kyambogo University. He is a scholar. He is a teacher. He is a lecturer. Ladies and gentlemen, Paul Muchibi is a founding partner of Kyeyune Company Advocates. And he has been at the forefront and consulted this for electronic and virtual modernization of courts. For 2026. Wow. Gentlemen, coffee and tea and soda on the house, so the snacks behind. They have been sponsored by they may not sponsor next time if I don't mention that they have sponsored this. Ladies and gentlemen, let me take this opportunity to also introduce Professor Wale Adeyemo. He obtained his bachelor's degree from Bayero University, Kano, Nigeria Law School, where he's a barrister at law. Ladies and gentlemen, he pursued his PhD and obtained it in the esteemed Islamic Science University of Malaysia. His area of PhD research is Islamic banking and finance. He has also worked as a lecturer at the Kano State Polytechnic, Lagos University. Adeyemo is also behind number of them. Abdullah is the current Dean of Law at the prestigious Islamic University in Uganda. Let us put our hands together for Doctor as he comes in front. There is, I call him the usual suspect because he is always available as and when you need him. But before I invite him, let me take this opportunity to invite Dr. Brian Kalenge. And ladies and gentlemen, Dr. Brian Kalenge is the Dean of Law of King's. Dr. Brian Kalenge holds, prior to his leadership role, he was a senior lecturer in the Faculty of Law at UCU. He has made a number of publications. Dr. Kalenge is an active scholar whose work addresses critical gaps in African jurisprudence, particularly in transitional justice and international law. Dr. Kalenge has been associated and established law firms including Kalenge Bwanika and the Company Advocates. Ladies and gentlemen, Dr. Kalenge holds a PhD in law, and his research focused on comparative constitutionalism and is the current Dean of Law of King Caesar University in Kampala. Ladies and gentlemen, let us put hands together for Dr. Kalenge. Ladies and gentlemen, let me also take this opportunity to welcome Associate Professor Captain Shadat Semakula Muhammad. Captain Shadat Semakula Muhammad is the Deputy Dean of Law at Utamu University. He holds a Bachelor of Laws from the University of London, an LLM from Kingston University, London, a PhD from Brunel University, London, and is a consultant with Uganda Management Institute and a lecturer of law at IUIU in Uganda. At Utamu University in Uganda. Let us put our hands together to welcome Associate Professor Shadat. Ladies and gentlemen, now let me take this opportunity to also introduce to you the usual suspect on these forums, Professor Christopher Mbazira. Professor Christopher Mbazira has served in a number of positions at the prestigious Makerere Law School, including Dean, including Principal of the school. He's the brain behind Public Interest Law Litigation Clinic at Makerere University. He holds an upper degrees, a bachelor's degrees in law, second class honors upper from the mighty Makerere University. He has a master's degree in human rights from the University of Pretoria. He holds a PhD in law from the University of Western Cape. He was promoted full professor in 2020. Professor Mbazira is an associate professor at Dula Omalo Institute at the University of Cape. He serves as Uganda Law. He serves on the Uganda Law Council and the Management Committee of Law Development Center. He's a board chairperson of FIN Uganda. He is widely published. Those of you who have also been following, he identifies himself as a person who carries out strategic litigation. For the young men here may not know, but if you have come across what we call as amicus curiae, he was the brain and the architect of the first amicus curiae case, which is a precedent in this country. Let us put hands together for Professor Mbazira. So, ladies and gentlemen, this takes us to the beginning of our discussion today. My name is Tony Kire Galandi. I am the managing partner of Diamond Advocates, where we have taken it upon ourselves with the support of distinguished people like these ones to promote legal technology in this country. And I'm glad that a number of these gentlemen, when you call them up, they have always been there available amidst their very tight schedules. Ladies and gentlemen, we are going to give our panelists, each of them, 5 minutes, uninterrupted, no question, no nothing, where they are going to give us their law school 3-year digital roadmap in the environment where there is digital disruption. We believe that even in the absence of the enabling structures, even in the absence of the enabling policies, universities have been able to take baby steps to put in place some kind of roadmap. And I will start right here with Professor Mbazira. Kindly share with us the roadmap in 5 minutes and interventions the university has put in place in this era of digital disruption. Over to you. Thank you.
Thank you so much, Tony. Good evening, colleagues, ladies and gentlemen, online and colleagues present here. It's a pleasure to be here. Indeed, we are living in interesting times and we must catch up with the times. So we don't take opportunities of this nature for granted, because there is quite a lot that we can share. There is quite a lot that we can learn. I'm so happy to be sitting here with my colleagues, fellow academics. We are in the trenches together. We are doing so many things together, but at the same time, there is a lot that we can learn from each other. As introduced, I'm a professor of law at the School of Law in Makerere, where I've taught since 2001. I've risen through the ranks. I've been part of a number of initiatives at the school. And as a School of Law, we are challenged in a number of respects. But one of the most challenging, and I know this is not unique to Makerere, but it's a challenge that all universities or law schools face world over. It is catching up with the times. Why? Because the law is a unique discipline in the sense that the law interfaces with all other disciplines. So every change that happens in medicine, in social sciences, in engineering, usually affects the law, and the law has to respond. And if the law has to respond, of course, at the place where lawyers are manufactured, too has to respond. But sometimes we are not able to respond with at the same pace with changes that could be happening around us. So we are challenged. Nevertheless, we try in spite of the limitations that we have. Some limitations are contextual to particular universities. Some limitations are discipline-wise. The law as such. Some challenges face legal education broadly. And we try to deal with those challenges. So technology is one development that has really challenged us. And as much as we are hyping it now as a new thing, it's not new. I remember when I was graduating from Makerere in 1999, Tony, we were challenged to have skills to use a computer. And a special short course was arranged for us to use a computer. And we were told this is a mouse, this is what a mouse does, this is a keyboard. But at the end of the much of what I do with the computer now is self-taught. It's self-taught, but we were challenged, and the law school was trying to catch up. When we look at technology in the context of legal education, there are like 4 areas where technology is relevant before I go to what we are doing in Makerere. Number 1, first of all, there is technology as a tool of teaching. And that's, first of all, the hardware bit, the classroom setting, whether it has technology. That's an issue that needs to be looked into. There is technology, again, as a tool of teaching. For instance, when you are doing online classes or when you are doing hybrid classes, we were all challenged during COVID, the COVID lockdowns, and we had no option but to quickly adapt and actually begin using Zoom to teach, later Google Meet and other platforms. Number 2, there is technology as a tool of research, especially for academics, because we do a lot of research. We write journal articles, we write books, we write research reports and things, so outputs of the like. And as we process our research, we have to use technology, or we need to understand the role that technology can play. We just saw the demonstration we had at the start. There is technology as a tool for students in their student research and work. That too has its issues. Then lastly, there is technology as part of the content of what we teach, as part of the syllabus, as part of the curriculum. And as law schools, we are grappling with all these areas of technology. I'm quickly going to, I know I'm running out of time. Let me quickly go through what we've done and have not done, because we also challenged. Number 1, technology as a tool of teaching, the classroom setting, using different technologies that are available. We've tried, but of course we are challenged. Some of the technologies are expensive. We cannot afford them. Simple technology like projectors, yes, we have them, but using them sometimes in a class setting is not easy. But there are other technologies as well that we've not been able to acquire because of challenges. But recently we commissioned a video conferencing room, a video studio at the School of Law. We are getting to grips on how to use it. It's new technology for some of us and our students. Of course, we do online classes. Makerere has a policy on hybrid teaching. It is now part of Makerere. You can do hybrid teaching, combining physical and online classes. So we use quite a number of platforms for that. The most common, of course, is Zoom, Google Meet as well. We use it to teach. Technology as a tool of research, that's a challenge. We've not yet, how should I put it? Of course, we are using internet, which is technology. But when it comes to technologies like AI research that Augustine shared with us earlier, in that respect, we are lagging behind. But we are mindful of the need to have things like that. But we are yet to put that in place. Technology as a tool for students. The students are using it, but we are challenged because as much as they can use the different technologies, ChatGPT and other AI technologies, at the same time, there are rules that have to be followed, or there are rules that are in place, especially rules around plagiarism. We've faced a bit of a problem with that, although the university has an anti-plagiarism software that we use to check whether a student has plagiarized work that they have produced. But some of these softwares are not catching up fast enough with developments in AI. So we are not able to check certain AI technologies. We also The university is working on a policy because there's need for a policy on that. My position as a person, and this is the position that we've pushed at the university, is that students can use AI, but they have to use it in an ethical manner.
Thank you very much, Chris. Students can use AI, but must use it in an ethical manner. As a university, we're pushing for policies for regulation and the use of AI. Thank you very much. And over to you, Dr. Brian Kalenge. Time. We overshot, I think, by 1 or 2 minutes. So don't feel offended when I cut you off.
Well, you didn't tell us the time.
Oh, I said 5 minutes.
Oh, you said 5 minutes.
Yeah.
Okay. Good evening, everyone. I'm happy to be here. It's my first time here. My name is Dr. Brian Kalenge. Just to set, I think the correlation to Bwanika, Kalenge Bwanika, is not right. He's my uncle, but I did not start his farm. But anyway, beside that, going to the topic that we are discussing today, I think it is something that is contemporary but also very topical. I think it's something that each and every one of us is battling with, not just in as far as academia is concerned, but in our day-to-day lives. I'll start with King Caesar University because I think that's the gist of what you wanted to hear. We have been trying to introduce various advances and digital systems within the university that are applied by both the university and by the students. So we have ERP, or enterprise resource planning applications, which deal with students' results, which deal with HR issues, which deal with admissions. So those are the more mainstream ones. But we also have an e-learning system for our students, which we call LMS, the Learning Management System. Now that one helps for pretty much everything. So for example, students are going to get their coursework there. They are going to once their coursework is finalized, they're going to submit their coursework through LMS. They are going to get their results through LMS before then it goes to ERP. And that simplifies the process, but also for us as HODs and deans, it is easier for us to supervise because you just log on to the system and see which lecturer has submitted which coursework, who's not yet submitted. The deadlines show up, so you have it's highlighted this is over the deadline, and that helps us to keep track of what is happening. Also within the e-learning system, within LMS, our students have access to all the notes and materials for that course unit. So if, for example, you're studying constitutional law, and you start in constitutional law in 1-2, not constitutional history, but constitutional law, you will have all the materials for constitutional law on the first day. So the notes, the reading materials, the constitution, whatever it is, it will be there for you to access. So that is very important for us, and we ensure that we constantly update the e-learning, the LMS. New cases, new laws, we insist that these are constantly updated. So every beginning of semester, we remind lecturers, please update the information you have on the e-learning system. We also have a repository system for our research publications for both lecturers and students. So when students conduct research, we don't just throw it away. We have soft copy of that research, and then we put it there. So it is there for posterity. So even if you left King Caesar in 2025, 30 years afterwards, we shall know what you wrote about, and we shall know how, we shall be able to follow up and see what happened after you wrote about this one topic or that other topic in terms of your research. So that is in terms of the systems that we have. But I also wanted perhaps to add on to my colleague, Professor Mbazira, what he was talking about in terms of the actual utilization of digital mechanisms or digital tools within, for example, the classroom as pedagogical tools to aid in teaching. We have been trying to encourage lecturers to use digital tools as opposed to the old-fashioned way of teaching, whereby I was in the same class with Mbazira. I can tell you, we never saw what do you call it? These slides, the PowerPoint presentation. All our years at university, I don't remember one lecturer using a PowerPoint to teach us. So we've been encouraging lecturers use PowerPoints, use visual aids, things like when you're teaching human rights, but you have never shown people about the Human Rights Council, how it operates. You're teaching international criminal law. You've never the ICC. It's an alien concept. It's only on the book. Show people cases how people practice in international tribunals. You're teaching IHL. People don't know about the Second World War. They don't know about international crimes. They don't know about the crime of genocide. And yet those visual aids exist, even free of charge online. So there's no reason why we do not use these visual aids. They're very easy to use. And we have been encouraging our lecturers to use such aids in their teaching. We also encourage online classes, but with a small provision on that, because with you students, I think you know yourselves. Once you have online classes, sometimes someone says, I was learning online, and they were doing completely something else. So we have limited online teaching to only 20% of the actual teaching that takes place at the university. So we try to ensure that we use our online teaching for visiting professors, or professors who are not in the country. So we have visiting professors from South Africa, from Ghana. So we ask them to do online teaching just to boost up what our local professors are actually offering. Then in terms of research and in terms of research tools, we use LexisNexis. I'm very happy to see this new tool. It's called Sharia. Yes, I'm very happy to see it. I'll be having a small word with Austin after here and see the financial implications of what he has developed. But I think these are tools that can be used for research, for students and for lecturers. We have had an over-reliance on ULI for a very long time as a tool in Uganda. So, and now, you have these AI, artificial intelligence tools like ChatGPT. What's it called? ChatGPT? That one. My colleague Mbazira approves of it, but I'm still old-fashioned. I'm not too sure about that thing because I don't know the boundaries. You understand? I don't know how much is you thinking and how much is AI. Because when you go, my colleagues will tell you, when you go in court, you don't have GT or whatever it's called. When you're at the bench, so when you're at the bar, so it is important that you have a limit to how much you use and how you use it. So we have insisted on the older tools, which is LexisNexis, which is something which we have all used, especially at postgraduate level, and then ULI, which is absolutely fine, and these are used for research. Then of course we have the anti-plagiarism tools as well, like Turnitin, which determines the level of plagiarism that has been done. But like he rightly said, even now we have problems with Turnitin because you don't know how much of it is plagiarized through ChatGPT. You cannot tell the AI aspect of it. And that's one of the problems that we have. So I guess I'll stop here for now, just to be able to keep time.
Thank you, Dr. Brian Kalenge. I was taught by Professor Mbazira, and during our time for us, it was hardcore. They will tell you, go and read this volume of cases. Yeah, and now when I see developments by Austin and where tools are analyzing cases which we used to go to the library and read 20 of them, I think it's amazing. But I think for me, my take home from Dr. Brian Kalenge is us accepting and appreciating the fact these tools are there and the students are using them. And we need to have a conversation on how best do we help the students so that the students remain relevant, because like he's saying, ChatGPT is not going to be in court with you. You are going to proceed at the bar as you. This takes me to my friend Muhammad Shadat, professor. Professor is from Utamu University. So the technology, because he's from a technology university. That's why I want to ensure I warn him of time early. Thank you very much, Professor Semakula Shadat.
All the guests that were called upon to attend this important session. Okay. Sorry, I was disturbed, but I don't know why this gadget came near before me. When others, when they started, there was nothing like a gadget. So I allow me to salute you with the best salutation chosen by Allah. Assalamu alaikum wa rahmatullahi wa barakatuh. May mercy and blessing of Allah be bestowed upon you who has traversed to such an important session. I do take my salutation to everybody on the panel, but much gratitude to go to Professor Mbazira, who has been a guru in transformation of pedagogies in all universities to see that delivery of courses is changed from the colonial to the modern tools. I'm profoundly humbled that the university I'm presenting is the guru and the international hub in Uganda when it comes to digital knowledge. UTAMU is the leading university when it comes to digital migration, digital applicability. All the courses on UTAMU are online. Exams are monitored online. 85 of the students who lecture on UTAMU, others come from Lesotho, South Africa, Malawi, Zambia, and they're using the digital platform as of access. As we advance, it is important the general consensus amongst the legal thought, they have all agreed that education needs to be redesigned. The lawyer of the 21st century. Technology is multidimensional and encompasses lawyers as users of legal tech, and it is important that all universities should adapt the technology. Engineering education for the digital age requires integrating digital skills and technology into the curriculum to prepare graduates for technical-centric legal field. I believe that reintegrating legal technology requires a balanced approach that leverages technical innovation and enhanced access to justice. It is incumbent that the traditional, or what I call the colonial pedagogies, should be aborted, and universities should adapt the technology to suit the demands of the century, because technology makes less stress for the students when they are doing research. They can use applications like predictive coding, ChatGPT, heavy case text, that within a second a student can easily summarize and understand the case without the longer traditional of carrying so many books. At UTAMU University Law School, the LLB is blended with IT law, emerging technologies. Some of the courses like IT law and emerging technologies are taught, ICT application, ICT systems, computer and the law of artificial intelligence, cyber law, legal informatics and legal innovation, cyber law and ethics, and legal innovations are part of the curriculum. It should be noted that all the curriculum, the students are more prone to online than the traditional mechanism of learning. The law of artificial intelligence and legal informatics and legal innovation are core courses to be taken by all students at LLB and LLM at UTAMU University. UTAMU has also introduced an LLM in intellectual property and information technology law that blends information technology, including emerging technologies, that combines the classical study of IP with rapidly emerging field of information technology. They have also advanced in the LLM in natural resources law, LLM in commercial law, it should be noted that at UTAM, all curriculums at UTAM have been designed to integrate digital literacy and also bridge law and new technology and foster the application of the legal technology. It also incorporates the use of AI-powered resources and other digital tools to enhance learning. It covers digital justice and ethics. Access to justice in digital age means using technology to make legal information, services, and remedies more available. Accessibility to justice can always be achieved through IT, or what I call artificial intelligence. Training at UTAM will run a legal clinic, which will be run by the students, supported by the law school. As part of the support of the students, all the students are now getting equipped with the digital tools, including online portal, virtual learning, AI to help people solve legal issues, mainly through ADR. UTAM as a leading hub for digital transformation and AI to students. All the students are trained to master technology before graduate in order to improve efficiency, transparency, and also to match the demands of the world. So, today, I call upon all the students here. The evolution of technologies, e.g. AI, and others are so important that all law schools in Uganda should emphasize and abort the traditional colonial pedagogies that were used and integrate all the curriculum with artificial intelligence. This would make Uganda global and will make the students of Uganda to match the demands of the world. However, as we advance, it is also important that the government of Uganda, for issues of integrity, there are so many applications of artificial intelligence that we need a policy on AI, artificial intelligence, and the law. This would help what we call the fake detective mechanism, that at times we have what we call the deep fake presidents. You'd find we have a challenge recently of the case of Besigye, where the voice of Besigye, one would argue is the voice of Besigye for criminal proceedings or cross-examination. Now, who is to examine that? There are so many tools in the world. So as we also advance, it is important to the students that there are so many tools of AI, and there is a need to detect. And detecting, because of so many, universities have to invest a lot because it's very expensive. And also, as we move on issue of credibility, because of the so many AI, we need to be very cautious. However, as lawyers, like we have the Evidence Act and Misuse of Computer Act 2011, teaching our lawyers the usage of e-discovery tools as an AI or predictive coding technology will help our students when they are analyzing judgments, cases, so that if you have a client, it is easy to predict the success of the case in a short time. In those
thank you very much, Professor Sadat. Teaching our students predictive tools, the government should be, should be happy and intentional in developing policies that are regulating the use of AI in the law. The teaching of cybersecurity and digital systems is what Prof is telling us. He says the conversation must start. And also, for the record, professors and deans of the law schools, we have a repertoire around, and these views we are presenting, we hope that we should be able to come up with a paper that should be able to guide this education, this nation in the legal education. Because if we don't do it, who else will? And there is no better person to streamline, because ideally the people who are guiding us and not following these conversations. Whereas Professor Mbazira, Dr. Shadat and Dr. Chisubi and Dr. Brian are having these discussions here. National Council for Education that says, okay, this is what you should teach, is quiet. So should we also keep quiet? The answer is no. The Law Council that approves some of these courses, is not necessarily up to date like we are, but we should be able to start this conversation. So after this conversation, we'll be able to wrap this up, and don't get tired of us, because we'll share these views and come up with something that we should be able to present to the authorities that be. Thank you very much, Professor Semakula. That was very, very insightful. When Professor Semakula starts speaking digital, you have to just twist to turn him off, because he lives it. Over to you, Professor Adayemo, Wali Abdulatif, Dean of Law, Islamic University in Uganda. Thank you.
Assalamu alaikum wa rahmatullahi barakatuhu. May the peace and blessing of Allah be unto every one of you. Firstly, I have to seize this opportunity to thank the organizer of this panel. At the same time, I recognize all my colleagues, likewise our students that are here, and then those who are also hearing us online. Assalamu alaikum. My name is Dr. Adeyemo Wali Latif, the Dean Faculty of Law, Islamic University, Uganda. Actually, Islamic University in Uganda is a very unique. This is because we are training our students in Islamic law as well as a common law, that is to say secular law. All the subjects relating to common law, we have those subjects also relating to Islamic law. Then, when we are talking about the issue of technology, digitals, as well as data analysis, Islamic University in Uganda, we thank God, we are not in the backward at all. If not, we supposed to, in which we are the, if not number one, then we have to be in number two. This is because, if you could remember before, in the olden days, teacher used blackboard with what? Chalk. Now we are using whiteboard. Maybe tomorrow, based on the development, you can be able to use what we call, maybe, for example, now we have some computer now. When you are talking, then they will be writing it down for you. So we believe that the way the world is going, in future there may not be any problem. This is because, as Almighty Allah said in the Quran, the first revelation, Quran chapter 96, He encouraged us to seek for knowledge. In as much as we are trying to seek for knowledge, our father, the little knowledge they have, during our own time, then it was increased. We believe that the young future lawyers also, they will be also able to contribute. So in order not to waste time, when we are talking about the data development, IUIU, we have what we call ERP system. And then in year one, first semester, we educate our new students to know about computer application in which they can be able to know the way and manner of applying all those digital way of learning. We also have what we call communication skill. This we assist them in first semester year one. Then with this, it assists them relating to our ERP system. The ERP system, the lecturer are using it. Your publication, like a faculty of law, we have IUIU Cooperative Law Journal. If you want to know much about our journal, go there, as well as other faculties also. We have all this journal, we have both hard copies and then online copies. Beside that one, the student also, by making use of ARP, even before they can be able to gain admission to IUIU, then in our website, everything is there. The payment, and then the cost of life, or whatever may be the case, you get it. Even the way the students are paying, we are not collecting cash. They have to go to bank and then upload everything in the ARP. So beside that one also, in almost all our classrooms, we have what we call CCTV. That one monitoring the movement of the lecturers as well as the attendance of the students too. We can be able to see that these are the development of what we call technology development. Now, in online classes, we have online classes, but it is a minimum. In a semester, online classes should not exceed 25%, where physical one has to be 75%. That is the system we are using. And then even if the student attending class online, through the ERP, then we can be able to generate as well as a movement of the student, because some students may just join online and just leave either the phone or the computer and continue doing another thing. No, we can be able to detect all this one through our ERP. Then all the universities in which IUIU have a memorandum of understanding with, especially those who are having faculty of law, we have what we call a collaboration, in which exchange a program, we make use of them, and then they teach our students online. So these are the way and manner in which we can be able to see that the use of technology are moving well at IUIU. Then, coming to the issue of AI, artificial intelligence, as well as in the other area also, by way of to detecting plagiarism. So we make use of it. Whether you are writing textbooks, journal, even the assignment given to the student, there's one principle that we normally use. We have what we call test week. This test week, it always comes maybe between 11 or 12 weeks in which the student started a semester. This test week, the students have to upload. The test will be sent to them through their ERP, and then they have to do it through the ERP and submit it. And then the lecturer will mark it through that the ERP. Beside that one also, IUIU, being we have some campuses also, the other system that we are using is by way of joint setting of examination questions, then joint moderating, as well as joint marking also. So we can be able to see that those who are in Bali and then those who are in Kampala now, so we are using the same syllabus. We set the question, then moderating both internal and external, as well as we gather ourselves together in one campus, and then we mark it, and then we upload the result into ERP system. So beside that one also, the payments, even the lecturer, if you want to know the total number of a lecturer we are having, go to our ERP. All this, the publication or whatever, you can be able to get it in the ERP system. So, however, the issue of online classes, so IUIU, we don't have any problem relating to that. Then, moving on also, we have what we call projectors in some classrooms. So where you can display or the use of a PowerPoint, especially for those postgraduate students also. And then the students that are LLB undergraduate also, they can also enjoy all those projectors also. Then, as IUIU also, when we are talking about the issue of research, So the research is a compulsory, even for the lecturer, especially when you are looking for promotion. Therefore, it is something that you don't need to play with, unless if you don't need any promotion. Once
Wow.
you need it, then you have to prove.
Very, very powerful submissions by Dr. Ademayo.
So thank you.
My take home, like many of you, he says at IUIU, they have put in place a system where a student uploads the work. You do the assignment, you upload on the system. The lecturer is able to see it and mark on the system. I think for me, that is a move in the positive direction. And I think soon IUIU throwing the people who are making papers out of business because you are going digital. Thank you very, very much for those very, very strong submissions. Without diluting your very powerful submissions, I won't go further. And I am on purpose going to skip Dr. Paul Muchibi because I want him to come last. The reason I want him to come last is because he waits for us students at last at the center. Therefore, I will want to move to Dr. Chisubi Esther. Dr. Chisubi Esther, over to you. What is that you are doing that is different from other universities? What is that you are doing as a way of improving legal tech education in Kampala International University? Over to you, Dr. Chisubi.
Thank you very much, Chair. Good evening, everyone. Protocol observed. Dr. Chisubi, Dean School of Law, Kampala International University. When we talk about legal tech in universities, yes, for the general university, we have incorporated the technology, exam management, research. We have Tantin, where students, before you submit your research, you must subject it to Tantin. And it's required to have 20% of plagiarism. We are checking plagiarism. So our Tantin at Kampala International University checks even AI. So AI is, we are still in the talk, we are still talking to see what percentage do we allow AI. Because at somehow somebody was asking, should we limit AI use? Should we limit AI use? Avoid it in university? But this is where to go. We are in the 4th generation. Internet of Things. We are training the Gen Zs. They are doing research using AI, and tomorrow they will be the justices. So definitely, since they don't know how to do what Professor Muchibi was doing, going to the library and research, then you write what you have copied in the textbook. These people, they will they use AI for analysis of the cases. So we as educational institutions, what are we doing? Yeah, we have online learning portals where we do blended learning, which this is where to go. Blended learning, where we have online percentage, 25%, then physical. Then, because where I don't want the experience of where Professor Muchibi was saying, Professor Mbazira was saying that they didn't know how to use a computer. Right now, National Council for Higher Education has made computer compulsory for all universities, but they learn the basics. Now, we as the lawyers, how do we incorporate the technology into the learning of education? We are currently under curriculum review. How do we, because as Professor Shadat was saying, the legal education system that we inherited in Uganda was designed by the colonialists, which is so conservative and was textbook-based, library-based. Now, as we are teaching, right now, the Gen Zs. The lower education system has revised their curriculum, which is CBC, competence-based learning. So the legal education also should get out of the conventional way of doing things, and we get into competence-based. We want to train a competent lawyer who will be able to use AI, to use technology to urge out the client case without violating the ethics. So this is our call to the regulators. You did good to skip the regulators, LDC, the Law Council. They have to come up with a code of conduct. They should guide us. How do we use technology without violating the code of conduct of legal practice? For example, we have the principle of confidentiality. How do we protect the data of our clients? Because we shall be uploading. Because we are saying we are moving away from storage in the library, we are going to the cloud, we are storing that. Which like AIU, we have space where we store our materials. But now, how do we protect the KIU materials from being stolen by another university? This is what we are asking. Can we train our lawyers? Can we train ourselves to use this data without violating the IP laws? Yes, in our curriculum at KIU, we have IP, intellectual property, that we teach. We have ICT law, we have cybercrime law, but currently it is elective. So the regulators, the LDC, they have not made it mandatory that this one should be core, such that everyone is trained, because this is where we are going. We are not going back. So if you find, the regulator will say, okay, include technology in your system, but it's not core. So for us who are teaching, who are feeding LDC, we shall say, these are our core, we put emphasis on the core, and we ignore the most pertinent issue right now. So in as much as we have it in the curriculum, it is still elective. So we are moving towards that. For use AI technology for teaching, right now we have at postgraduate level. Undergraduate, we used it during COVID time, 2020, 2021, and then we stopped because of the evils. We were taken by surprise. Everyone was learning how to use technology. You tell the students, log into the Google Classroom, they don't know, log into the LMS. All these gadgets are there. We saw, I think it was a video where so many funny things were happening in online classes. So we said, can we prepare ourselves now to embrace technology? You know, students can log in and they decide to do other things. They will appear here in the system, but they are doing other things. So they miss out. So are we prepared as the universities? This is the talk we're having at KIU. How can we manage this? Yes, we have revised our curriculums towards that, but embracing it, we need emphasis from the regulators to help us. Thank you.
Thank you very much. Dr. Chisubi. Dr. Chisubi says LDC is folding hands. He's not telling us we should make computer science a core subject, because as a training institution, we prepare these students for the center. Now, if the center is not intention on what it wants, what do we do? The young men do not want to have computer probably when he has another course, which allows him to go and practice a bit. So over to you, Dr. Paul Muchibi. You lead the research at the only regulation body for the students, that's for the bar. You have equally published a lot in digital, about digital transformation. You have presented on various conferences about digital transformation. We are saying, can you help us walk the talk? What are those interventions at the center you are putting in place as you receive the young men from the law schools to prepare them for the current digital age? Now you realize why I have to make you come last. Over to you, Paul.
Thank you, Tony. Allow me also greet all colleagues here and those listening to us virtually. Let me begin by correcting Dr. Esther and partly Tony. LDC is not your regulator. Your regulator is National Council for Higher Education in collaboration with Law Council. I think let's make a difference. And that has been a very big mistake universities communicate to students. And students end up thinking LDC regulates them. No, LDC is also regulated by your regulators. It is the National Council for Higher Education in collaboration with Law Council. So I wanted to make that clear, such that you know where we are coming from. Second to that, Tony, I missed an opportunity. I would have enjoyed this discussion if Law Council was seated there. I would have enjoyed this discussion more if National Council for Education was seated here. Because these are implementers. They don't regulate. So if their ideas have not been adopted by the regulators, it will just remain an open what? Discussion. So as you said, moving forward, I would want to face an interaction with Law Council, with National Council for Education. Law Council, which is still grappling with manual enrollment. And I don't know where it is now when it comes to digitizing curriculums. So I want to begin by saying that I don't want to go into e-learning. Majority have spoken about it. And after COVID-19, e-learning was almost obvious for most institutions, not only even in law schools. I've been, and I'm still part of the university and at LDC. At least I've not had any speaker who has spoken before me talking about their curriculum, how it is integrating digital learning, specifically imparting digital skills. And that confirms my statement I've delivered even in another training this morning at UCLF that legal education and training in Uganda largely remains doctrinal, analog, and distant from digital applications. Instructors themselves are still stuck in analog. It is a very critical cause, except UTAM, which I've heard that its curriculum is already integrating digital applications and digital skills. Most of the universities remain analog. When we talk about digital applications, we are discussing e-learning, e-assessment, e-RP. Those are distant from what we want a lawyer today to be. A lawyer of today. Let me begin with this. On 1st March 2022, the judiciary switched live ECMIS. That's the Electronic Court Case Management Information System. It was switched live on 1st March 2022. Law schools, 3 years down the road, still instruct practical subjects in a manual world. I'll give examples of two: civil procedure and criminal procedure. Go to year 4, year 3, depending on the university where civil procedure is offered. Students are being taught how to file documents in court, and are being taught how to file manual papers, how to go to the bank and pay fees, how to go to the court registry to get a receiving what? Stamp. Our courts still doing that. So what are we instructing? There is a very big mismatch from the practice happening now and what is being instructed in law schools. Here we are filing by uploading documents on the system. We are using e-payments. We no longer run to the bank. We no longer have to take a hard copies to the register to have them what? But students, this is being taught now. So you can see a mismatch between training and practice. It's very big. And that will answer your question, Tony, the first one. What is LDC doing? I'm speaking from an institution that imparts practical knowledge or practical skills. LDC has already incorporated ECMIS training. It is under the legal aid clinic. We collaborate with the judiciary, and we are training students how to file digitally, how to pay digitally, how to proceed virtually. And this resonates with the judicature, electronic filing, service, and virtual proceeding rules, SI number 21 of 2025. I fought a battle to have that legislation. In 2022, ULS had an AGM at Entebbe, and I was invited to speak about ECMIS because it had been launched and it had worked for about 6 months. And I challenged the judiciary, which law are you telling us to file documents digitally? Which law are you telling us to pay digitally when the regulations in place are speaking about something different, which is manual? And I say, if somebody brings a challenge to you now in court, will you sustain this system? I'm happy the judiciary listened. They fast-tracked regulations. And as we speak now, we have SI 21 of 2025, which is accommodating. I was very key in coming up with that regulation. It may have issues which will be addressed later on as we move on, but at least the instrument is what? In place. I must say that on 1st October 2025, the Court of Appeal went paperless. 1st October 2025, Court of Appeal went paperless. I've asked the technical committee of ECMIS and the judiciary their definition of paperless. Does this mean less paper or completely no? Because the word is paperless. Does it mean less paper or completely no? I haven't got a definite answer for that, but I've been asking it. But the intention, they are saying that no more papers in the court. As students in law schools being prepared for this, they are still firing up with what? Paper practice or training. So LDC has been a pillar on ECMIS, and I think this should go back to civil procedure in law schools and criminal procedure, because even a case concerning criminal, that is how you are going to file it. It is e-filing purely. Secondly, LDC has embraced what we call virtual moot courts. When you are training our students, they also conduct virtual moot courts. And this again resonates with the judicature, electronic filing, service, and virtual proceeding rules. There's an element of virtual proceeding to prepare students to proceed in a virtual environment using facilities like video conferencing. And this is where we are supposed to be. This is how we should train these lawyers of tomorrow, because they will enter the field and they will find nothing you taught them in law school. And as far as commencing a case is what? Concerned. They will find a strange life completely from what they had in the what? In the learning. So we need to, as much as possible, work on curriculum. And that is where my concern is. The curriculum has to be revisited to have it resonate with the modern digital court. We are in a digital court. In very few months, you will see the court being rolled out, the digital court rolled out all over the country. It is moving very fast. So we need to revisit curriculum, and that's why I said I need a regulator here. Law Council, if your enrollment is still manual, are you ready for the digital training? Can you even avoid it now? Can you avoid it? It is impossible. You just have to think about it now very fast and integrate, because it is not going anywhere. The judiciary, why should we still continue applying pieces manually. With all these digital applications, you are enhancing. So this is where we are saying, let's start with the curriculum. Revisit the curriculum and make proposals to allow digital learning take place if we are to change the system. Otherwise, we are going to run a risk where a student graduates at the university, graduates at LDC, becomes an advocate, but cannot even file a matter in court. And you have to first undergo further training. I see UTAM has a postgraduate certificate in AI, that is postgraduate certificate in AI and the law. Then there's a postgraduate certificate in digital literacy. Now that means a student has to first undertake some of those courses to be aligned. Yet he has finished 5 years in law school, 4 at bachelor's, 1 at LDC. And when he comes out, he's called an advocate, meaning he's ready to take on business. But where he's going, the business is different from the training he or she has what? Acquired. So this is the time, no more wastage of time. We need to revisit our curriculum. We need also to work on digital literacy on both the instructors that train these students. Because if an instructor is not trained in the digital world, potea, you are not going to get anything. Because cannot instruct what he doesn't know. So we need to integrate and have this. Now, coming to AI-powered tools or platforms, Austin was telling us here. One he developed, which is trying to at least reduce hallucinations. And I've seen Austin illustrating, majorly, it relies on Yuli. In as far as cases is concerned, it relies on Yuli. Who tells you every case uploaded on Yuli is correct? Yuli is just uploads. It doesn't have an editorial board to scan through the credibility of these decisions. So, have you ruled out hallucinations? Because hallucinations relate to fake citations, fictitious cases, but also wrong decisions. I've been reporting cases of High Court. 3 decisions a day, shooting one another. I've also seen decisions disrespecting higher courts, precedents. You will find them all on Yuli. And you say you have defeated the hallucination. We need to do more. We cannot rely only on Yuli because it just uploads. There is no editorial board to authenticate the correctness of those what? Decisions. So our work is still more. That is a step which is also welcome to at least customer. This also will go Yuli as to whether it is authentic or not. Yuli should do what? Explain. Then Yuli will also tell you the judge is so and so. Who delivered that what? Decision. I've contacted judges in private when I've seen their decisions having fake citations. Some have cases relied on that don't exist. I've contacted some on a personal level. And that shows there is reliance on research assistants who also rely on AI and use it unethically. So, have you defeated the hallucinations? It's a bigger discussion.
Thank you, Paul. You realize that Paul will need a day to make a full paper presentation when it comes to this discussion. And this is just a tip on the iceberg. You realize that there are issues we need to address. And for me, this is really very, very key. Paul, you address very, very grave areas of concern. National Council for Education should be part of this discussion. Yes, it should. And that's why we are saying we are going to expand this discussion further by reducing it into a write-up, which we, in the next episode, we should be able to launch a white paper of some sort and make our calls on what we feel should be done. And it is in that conversation that we'll be able to expand further. I'm very, very... Exactly. So this is the beginning of this conversation. We hope to expand it further, but we needed to have it start. And I'm glad that I am having a team of very published of people who are very, very passionate about this whole thing here. Away from our usual approach, we are going to, Dr. Brian, you wanted to make a comment? Okay, Dr. Brian wants to run, but before he runs, these students want to ask you questions. So we are going to first have to open it to the young men here. The young men you see here, the young men, you know, you want to you want to incite violence, Dr. Chisui, to come after me, but the Bible says that man and woman remain the same thing. That notwithstanding,
But the
ladies and gentlemen, let me take this opportunity to welcome the presidents of the law schools of these different institutions. Do we have the president of Makerere Law Society? Stand up for recognition. It deserves a hand clap. Yeah? And the president of Islamic University in Uganda, is he around? Great. And the president of King Caesar University Society, is he around? And the president of Kampala International University Law Society. And the president of Wutamu Law Society, is he around? And the president of IUIU Law Society, is he around? So, it deserves a mighty hand clap. Dear leaders, deans of schools, we felt it very imperative that we could not have this discussion without the subjects themselves. And that's why we invited them to represent the broader spectrum of their colleagues. And I am going to entertain one question from each university, and you are going to ask that question to any of these people of your choice. But before that comes through, as you think through the questions, I will call on Dr. Brian Kalenge to make his comment. Thank you. Over to you, Dr. Brian Kalenge.
Thank you very much. Sorry, I have another meeting, so I need to rush out. I was very impassioned by Council Muchivi's presentation. Clearly, he's an expert in this area, and you can see he has a lot of background. It just brought a couple of things to the fore for me. Most importantly, there's a saying by these white people of ours that you don't put the cart before the horse, meaning that in the natural progression of things, there's a way in which you should begin to attempt to change well-established protocols or well-established procedures. Now, I was telling you that it has been, when we were in law school, we did not even have a chance to do PowerPoint presentations. But colleagues will tell you, people know, you yourself know, when did you last enter a courtroom and have a judge even use a laptop to take submissions? Huh? And as much as we want to, we want things to change, we also have to know the practicability and the reality of, one, our country, and two, how the law works in our country. So we might be rushing so much, that's why I'm saying putting the cart before the horse, to change curricula, make it digitalized, I don't know, have court sessions which are held in camera, and judge and witnesses who are cross-examined by I don't know what methods. But that's not what our courts do. Your court still wants you to come before them. You talk, even says, slow down. As he's doing what? Yes. He even says, where is the witness? I can't see him. If the witness is not there, adjourned, we are not proceeding. The witness has to be what? So, yes, as universities, we have a role to play. But this is where I agree actually with Council Muchib. The regulators, because currently I'm writing 2 curricula, and some of these things you'd love to put them in the curricula. But you know, once you put them in the curricula, they are just going to raise so many issues for you. So sometimes you're saying, okay, let us just take what they know and move on. So we need also to see that this fight, not only at the regulator, but even within the walls of practice. Because these people you're training, what are they going to do? You're sending them out to work as lawyers in practice. But in that practice, you do not have these tools you're talking about. So you're giving them tools that, in effect, they are not going to be able to employ in their day-to-day work. So there has to be a balance on how much you can do. Don't put the cart before, don't over, what's the word? Be overly ambitious. Because, by the way, even in more developed economies or more developed countries, where I have had a chance to either practice or be in court, some of the things we're talking about, they have not yet adopted for various reasons. And Dr. Chisubi spoke about some of them: confidentiality. How are you going to protect this information? If you're uploading a plaint onto a cloud, it has the address, the telephone number, of people. You're going. How are you protecting all that data? So many things have to change: data protection, confidentiality, what's it called? Ethics. Ethics, integrity, exactly. So I'm just I'm not saying we are being hurried, but I'm saying we should have some caution, if that makes sense. Thank you very much.
Thank you, Dr. Kalenge. Dr. Kalenge reminds me of a book I read when I was a young man, of a Wano Johnny Ruganda, who had a wife, and the wife was saying, too much ambition kills a man. And the man said, but too little takes him nowhere. So, before Dr. Mohammed Shadat comes in, I would want to first utilize this opportunity before Brian runs out, because I'm sure there are some burning young men who want to ask these very serious questions before he runs out.
Okay, I also need to make some response to Dr.
Paul, I'm going to entertain that rejoinder or rebuttal after we have picked up some of these questions, because we are here. So over to the public. If you have any question you think you want to ask, the microphone will be you. You'll tell us your name, your university, and the person you're addressing the question to.
Thank you. My name is Oku Philip Gordon, the president. Thank you so much. Once again, my name is Oku Philip Gordon, the president of the Great Makerere Law Society. It's a privilege and an honor to be part of this discussion. The moderator said we have just one question, but I'll kindly seek leave that I have a second question from my colleague. So mine is not a question per se, but a comment that most of the time when such a conversation comes up, it's how you're training students to adapt the digital age. But my comment or question would lie, how are you as our lecturers prepared yourselves to adapt to the digital age? Because the reality is that we as students, the Gen Z in bracket, are more flexible to some of these changes. But it comes back to you, how flexible are you and how prepared are you to adapt to some of these changes? Thank you.
Thank you, Mr. President of what you call the Mighty Makerere Law Society. That is subjective to you. I'm sure the one of IUIU will also tell you the Mighty IUIU Law Society. I think the young man is saying yeah, it's just generally that whereas you are telling them to adapt, are you adapting?
No, he's very right.
Thank you, the moderator. I would like to take this opportunity to thank our faculty deans, board professors, legal practitioners for honoring this session. And for the record, I am Alexander Kavengwa, the Information Secretary of Makerere Law Society. So my question is tailored to Professor Mbazira. He hinted on 3 aspects that reached my mind. One of them was technology as a mode of teaching, technology as a research mode, and technology as an aid tool for students. And he commended that students can use it if they use it ethically. But I want to pose a question. These AI models, allow me call them algorithms. They are tailored on data that is twisted or like engineered by foreign norms, which are actually not directly related to our customs as Ugandans. So my question is, how do we decolonize these foreign ethical standards to fit our arena before we teach students to trust them or use them?
Thank you very much. How do we decolonize the algorithms? Your name and the university.
Thank you, moderator. Good evening to you all.
Try to be a bit loud.
Thank you, moderator. Good evening to you all. My name is Peter Tushabomwe, third-year law student from Makerere University. My question is tailored to Dr. Muchibi. Apparently, he says that AI models it's inevitable that they make mistakes.
Sorry, the name?
To Peter Tushabomwe. Yes, he says that these AI models give us apparently wrong approach to the questions of the law. So, my question is, you are faulting the AI models, forgetting that it's we the humans that tailor those judgments, and they are consequently uploaded on those various platforms, and AI picks them from there. How do you then fault AI for a problem it has not caused, yet it is coming from us, we the humans?
Thank you very much. Why do we fault AI for problems caused by ourselves? Very serious question. Eh? I am not allowing anybody from Makerere University, and if you are from Makerere, don't bother, because those are 3 slots you have so far used. The name and the university.
To Professor Paul, he's talking of curriculum. Which specific changes should be made to Uganda's law school curriculum in order to incorporate technology, digital ethics, and access to justice?
Thank you.
At the second one, but you come in late.
No problem. Let us have another person.
Thank you so much. My name is Hasfa Nabagala from IUIU Kampala campus.
Hasfa Nabagala from IUIU.
From IUIU Kampala campus. My question is going to Professor Mchibi, whereby he was talking about AI and balancing it with fairness and transparency in laying judgment. However, when you see AI being incorporated somewhere, at one point in time you realize that it has replaced human judgment. So how are we going to incorporate the two, that is AI, in relation to human judgment? Thank you so much.
Thank you very much, Hasfa. One more lady here before I turn it back. Already Professor Mbazira has criticized me of being gender insensitive, so I'm trying to redeem myself.
Post protocol observed We apologize for coming in late. For purposes of record, my name is Chawarona from Uganda Christian University, Law Society. I am standing in for the president who couldn't make it. My post in that committee is the chairperson, Legal Aid Committee, and I'm honored to be here with all of us. So my question is, we have seen that AI is coming in. People are using AI, ChatGPT to do their work, to do their research, to do their assignments. And back our lecturers are telling us, go to the library, get those law reports, read them, and all that stuff. So what are we to do? You're telling us that we have to adopt. We are saying we shall initially have to adopt to them. But in the process of organizing and shaping the AI, what are we to do? Are we to wait and keep reading our law reforms, or are we to try and adopt it as it's being modified to being best? Because we can see that AI is going to give us deceitful things sometimes, yes, and it's going to mislead us. And as a profession really demands us, we don't have to be misled, because we shall mislead the majority. So my question really is, what are we to do? Are we to start getting to know what we are looking at, or wait and keep with our library, law reforms, and, Queen's Bench as we wait for what is to come? Thank you.
Thank you very, very much. Paul, over to you. They are saying we are at crossroads. Should we wait until you finish your digitalization process before we start using AI? Or, or we start now, and yet you are telling us the thing is lying? One last question. Which university?
Islamic University in Uganda.
Islamic University. Do we have any university that has not had a chance to speak? Which university? Kampala International. First give us the microphone. When we got space, I will give you an opportunity to speak. Kampala International University. And then? Okay. Okay.
Thank you very much.
The rest, you can write down your questions, and then we'll be able to share them. And those we don't answer, we'll still be able to write back to you.
Thank you very much, our honored hosts and everyone here, for having us. My name is Chemba Andrew, and I'm a fourth-year student from Kampala International University. So mine is less of a comment, but I want to talk about how Uli has basically been of help. So the gentleman that's the first speaker talked about summarizing principles and everything. I want to deviate from the opinions of most of my elders here that actually Uli does this. I've personally had an experience with Uli. Yes, there might be an issue of, is it hallucinations? But when it comes to summarizing principles, Uli has that criteria where it will bring out the issues and everything. It's actually called summary AI. So I'll actually deviate. It's being of help. Personally, I use Uli a lot. And then I would, a piece of advice to my fellow students here. We've been born in this .com era. Some of you guys have been using phones since you were age of 12. You've been exposed to gadgets. Universities might not have infrastructure in place to teach you all of these things, but I believe that it takes nothing to teach yourself how to file on ICMIS. If you look at the URSB, it has services that it offers to people. But in most cases, all it requires for you is to have an account that doesn't require a practice certificate. So it's more of a self-taught era. You can learn anything, and there is literally, the government will literally meet us halfway, and everyone that's supposed to play their role. Thank you very much. I remain Chemba Andrew.
So, Professor Mbazira, as an apostle, you have a follower who believes that, all work is not for you. They should teach themselves like you taught yourselves the slides. Yeah. Can I have the rest of the questions? And I'm going to ask, is Masa around? No. Can I have Austin pick the questions from these young men as they answer these ones? Then we can see if we can go back to them. So, is there any question to Dr. Brian Kalenge before he runs? So since he has been excused, before we continue, it is part of our practice that we give our guests a token of appreciation. Lawyers, lawyers and rejoinders. So So just 1 minute for a rejoinder before Kalenge leaves. Over to you, Paul. Do the rejoinder, then we can have.
Introduced here. Please go slow. Go slow. Don't rush these things. As they were still trying to go slow, judiciary was very strict. You either embrace the system or you are kicked out. This is the approach that is happening, like questions like Rona is posing. Do we adopt and integrate now, or we keep waiting? Technology will not wait for you. It is very fast and moving. We are talking about AI. It is coming in different phases, generative, predictive, what have you. So as you keep waiting, things are changing what? Every day. You need to start now. The only caution that Brian is putting forward is simply ethical considerations. As you embrace, you must be cautious about ethical use, not to abuse. But there is nothing like we have to go slow. Technology is not waiting for you. As I said, now 3 years down the road, ECMIS is switched live. It is working. So you can't wait. It is even changing applications. We are soon moving to execution online. So by the time you catch up with the filing, even execution is already done virtually. So the only emphasis is ethical considerations and issues to do with data protection. And that's why I mentioned to Chair, we need somebody from the Data Protection Office. We need somebody from NITA Uganda. We need somebody from Ministry of ICT and national guidance to tell us up to now why we don't have a policy framework on use of AI in Uganda. Because these are where questions are coming from. How would institutions at sector level come up with their policies when there is no national guiding policy on the use of AI? Because it can assist universities also to customize their policies. With technology, the more you wait, the more it leaves you.
Thank you very, very, very much. And now, before we answer our questions, let me take the honor to invite.
I concur.
So, Paul. Himself with your submission, and he has nothing to use. Let us utilize this 1 minute to do a small function for Dr. Kalenge before he leaves. We have a simple gift from LegTech Dialogues. So just come in front and I will ask Dr. Chisubi to come and do the honors. Thank you. I am paying for my sins. Just come over. Yeah. Just here. The camera people will. In the middle, so part of our culture here is we Dr. Brian Kalenge, Dean of Law, King Caesar University, in appreciation of serving as a speaker at the 5th episode of LegTech Dialogue podcast on re-hearing legal education for the digital age, convened on the 6th of November at the Caesar Certificate of Application Practice. Dr. Kalenge also, in our practice, we, as a way of promoting digital, we hope that every time you are taking a cup of coffee in digital dialogues, you will ensure that our students are adopting AI and learning their legal practice. Thank you very much.
Oh, we hold the thing. Yes. I'm sure it's not the only beneficiaries. Oh, just me.
Brian,
I apologize for interrupting.
Adam knows the only time he orders bosses around is when he has a camera. So utilizes that opportunity as a thank you very much. That was a great warm-up. And let's get back to our questions. I think I will start with Professor Mbazira before I go to Paul Muchibi. The questions that were addressed to you, please respond the young men. Thank you, and thank you very much.
Thank you so much, Atona, and thank you so much, our students, for asking the questions. I'm going to respond quickly. But before I do, Tony, I've had the unique opportunity to sit on the LDC Management Committee, to sit on the Law Council. I've also, of course, been an administrator in a university. One thing that usually comes up and what one sees is that there is always a ping pong, in the sense that the regulators are blaming the people they regulate. The regulated are blaming the people that are regulating them. The universities are blaming LDC. LDC is blaming universities. The employers are blaming LDC. LDC will always say, what crap are universities sending us? And then the employers will say, what crap is LDC sending us? And I think it's arising partly from a blurring of the lines, whereby, for instance, those who receive our products immediately after graduating from universities, they expect certain practical skills that should actually ordinarily be taught at LDC. I'll just give an example from what Paul has raised. The question of if I teach civil procedure in a university, I'm going to teach you what a plaint is, what should be in a plaint, cause of action, blah, blah, and all those things, the parties. It is now for Paul, I sent to Paul to teach you how to file a plaint. So if you get to LDC and you can't file a plaint on ICMIS, that's what Paul should do, to teach you how to file a plaint on. Why do I raise this? I think sometimes as universities we are unfairly bashed. Why? The Bachelor of Laws in any university is one of the most loaded disciplines. There is quite a lot that has to be taught in 4 years. And when I was dean, every month I would receive somebody who comes in and said, Makerere, you are not teaching this, teach. Next week, another person comes, universities, you are not teaching this. So it's a question of how much can we teach in 4 years. That's why we concentrate on the core that equips students with the core skills. Then they can pick up other skills elsewhere. I was just quickly checking this afternoon before I came here. Actually, even in advanced universities, because for certain things, for you to become an expert, it's not easy to produce an undergraduate Bachelor of Laws who is an expert in anything. It is not. It is not. But you give them the core skills. Those that want to be experts, either they teach themselves after graduation or they go for postgrad. I've seen that in even the most advanced universities in advanced economies, they're actually dealing with these specificities of AI in the curriculum, AI in terms of the law and technology at postgraduate level, because the Bachelor of Laws program is so packed. Of course, I'm not saying we should sit back. We are trying to integrate by streamlining certain things. So sometimes even the regulator, we are blaming the regulator for nothing, because the regulator is also interested in the core, and then other actors can build on the cores to then inculcate certain. Let me now respond to the question which was raised, the question of ethical use. It had an element of ethical use, then it had an element of hallucination and the foreign decisions. Let me begin with the question of ethics, because I may be misunderstood when I said it is okay for students to use those AI tools, but use them ethically. We cannot avoid the use of those tools. We actually we've used some of those tools for generations. When you do word processing and you are using word check, that is an AI tool, and so many tools of that nature. But whatever tool you use, and the students should listen to this carefully, ensure you avoid plagiarism. Because as universities, we are not about to change the plagiarism rule, that you can pretend to produce work that is not yours. That one you cannot. So if you use a tool that is helping you to do the research, first of all, you must acknowledge. I advise my students to acknowledge. I want to see a note where you say, I have used the following tools. And actually, what universities are doing now, they are adopting, and we are working on that in Makerere, policies where you must declare the AI tools that you've used and also the purpose for which you have used those tools. So for instance, you can say, I've used this tool to help me summarize the cases. You can say, I've used this tool to help me reconstruct the sentences. That has to be clear, so that if I'm marking, then I know what to attribute to you and what to attribute to the technology that you have used. But for you to go to ChatGPT, put a question, and then you copy and paste and pretend that that is your work, that is unethical. And that's what results into, people using those tools to write judgments that hallucinate, submissions that hallucinate, etc. Specifically on the question that you asked, how do we avoid foreign decisions? I think that's what Austin is trying to do by, using the local sources that we have. But it's sometimes not easy. I don't know Austin's profession. Austin may or may not be a lawyer, but that's the disjuncture that we are facing. In other jurisdictions where this has been very successful, it's because in some of those jurisdictions, Bachelor of Laws is a postgraduate course. You must have another qualification. We've tried to balance that. In our case, in Makerere, other universities could also be doing it. We allow graduates of other disciplines to... Tony, weren't you one?
Yes, I was.
Yes, exactly. We allow people from other disciplines to join the Bachelor of Laws. So if we have a computer scientist become a lawyer, then if that person is going to design those algorithms, they know what they are working on. And it may avoid hallucinations of this nature. But just to finalize, we need to localize. We need to pick interest in this. I think as legal educators, we also need to invest in this. I'll leave it at that.
Thank you very much. I want to put it on record. Austin holds a Bachelor of Computer Science and also holds a Bachelor of Laws.
Good. That's the kind of skill that we need.
In addition to Professor Mbazira, Professor Mbazira's submission, Professor Mbazira, as I've been the General Secretary for Law Deans, has always been calling all other universities to change in the pedagogies. Professor Mbazira is one of those icons in Uganda that has taken away the Spirital Index of Makerere and sees all law schools in Uganda as equal because they produce the same lawyers. When you become a lawyer before the court, there is nobody who distinguishes whether from IU and whatever. There was a colonial mechanics that had impeded other people to become lawyers, and there was inferiority complex. But through the prognosis of Professor Mbazira and I, as a Secretary General of Law Deans, he made sure that all universities are called upon. Is the founder of the Law Deans Forum to see that all deans we can unite, discuss, and through his innovative nature, I was able to join the International Global Law Deans. I'm a member of the Global Law Deans. We moved to different countries. Last time we were in Poland, then the next one in Switzerland. You learn globally how other universities globally are delivering law, and learning from others, you become better. So, on your point, as a student, you spoke about the challenges of Africanist ideology on our data. Allow me to respond. Lawyers and students should emphasize critical evaluation using prompt engineering and cross-checking outputs with authenticated databases like Yuli, Nexus, Lexus, and Uganda Law reports, because we know that we have so much AI generation material, but at least when you know of authenticated databases, that will take away the falsehood. The other one, we also have what we call deep fake precedents in criminal proceedings. How do you determine that the audio of Besigye or somebody is making something that is not authority? We have the deep fake and authenticate tool, which could be used in avoiding false video, audio, documentary evidence that have become a culture to you, the youth, using TikTok, Twitter, and others, where you have become authors of so many misleading information. So the students must learn digital forensic techniques. Some of these digital techniques that you can use, we have got the metadata analysis. This could even look whether the signature you are using is valid. They can also use the block-based digital timing machine, which are used when you are submitting records to the court. We have AI-driven forensic tools, e.g. deep wire scanner. This, they detect manipulated visual or textual content. This is important for upholding evidentiary and integrity, ensuring justice is an age of information manipulation. So those are my few remarks. And the last one, as you spoke, it was important in the submission that we have made that you put it on record, since the discussion for today is not a discussion for me, but is a discussion for entire Uganda. I have put here a roadmap, proposed roadmap for the National Council for Higher Education in conjunction with the government of having short term of 1 to 2 years curriculum, audit pilot courses on legal technology and AI. This should be able to be implemented in law faculties, National Council for Higher Education, and the Uganda Law Society. Then the medium could be 3 to 4 years. Establish legal technology laboratories, staff training, virtual clinics. This could be done by universities, judiciary, and donors. Then the longer term could be 5 and above, nationwide adoption research centers on digital justice. Government, private sector, and academia should be given. My main recommendation, moderator, National Council and Uganda Law Society revise accreditation framework to include digital competencies. Law schools institutionalize to have interdisciplinary research in all their policies. Judicial and Bar Association partner with academic institutions that can deliver and train and also give like CLE points. And last, government must invest. As you speak all this, it should be emphasized that as we are seeing lecturers struggling and complaining about wages, the question of financial implication on such bills, given that even access to justice is a miracle in Uganda, as we all struggle in our milestone to digital implementation, we should understand the vacuum we are playing with. Remember, even the Facebook in Uganda has been cut off. As we are discussing the digital migration, it is important to also bring into attention the political dynamics, the political vacuum we are implementing the transformation. And as we move, I also concur with Professor Mbazira and also my brother Muchibi that yes, we have to move. But I did all my degrees from England, and as a barrister, indeed, even England, they have not allowed some information to be digitalized, especially if you do read more about the Secret Act of UK and most of the information, because they know digital has no mechanism to control. So as we move, yes, let us sensitize others People are coming from poor background. Students do not have a laptop. Makerere, if you look at Makerere as the guru of law,
and
they
unfortunately, Prof, I have to cut
thank
you
you very
short. Thank you very, very much for those very, very insightful recommendations. And you have actually answered part of the question, which was supposed to be moving generally to everybody. And that means I will skip you when that question comes because it falls within that line. Over to you, Paul Mchibi, in 5 minutes. Could you answer the questions and then we'll do the wrap up, which will be a general question to all of us. Thank you, and thank you very much.
Thank you, Chair. Dr. Esther here wanted to come before me, but as you've elected, I think I can move on. One Gordon asked a very pertinent question, and I feel we haven't addressed it well. He's saying, how are lecturers ready to adopt the training and the digital age? Very pertinent question, which I think requires a lot to be put in place. And there is a very serious digital divide between the learners and the trainers. The learners seem to be so fast to cope up with the digital age. The trainers are still in a comfort zone. So there is a lot to do there. And this goes back to what Dr. Sadat has partly said. Training of staff is key in these areas. We can have short courses being administered like the ones UTAM has to the staff. And also to bring them to speed. Like the judges, when ECMIS came, most of them had never touched a computer. There is a judge I know in Kampala here who cannot even type on a computer. Is there in Kampala? I will not mention. Everything the secretary does, but his court has ECMIS. So you can see really the confusion. So we really need to have serious training of the staff and empower them to pass on the training to others. Then Alexander talked about decolonizing the algorithms. I'll join it together with the one who said, why, that is Peter, faulting AI, yet the information, I think Peter didn't get something clearly. We are not talking about faulting AI. We are saying what information exists in the domain that AI is picking from. Peter, today you can author some article. In one way or the other, it goes on the global page. Whether what you've authored has been peer-reviewed and authenticated, nobody knows. But AI will come and pick information from what? From there. Meaning, we need to have a proper ethical way of storage of our data, so that by the time this data is picked by AI, it is authentic. Which is still a bigger what? Problem today. We have no control of what AI is picking from. Even the cases, as I said, that come from some courts, some are decided per incuriam. But once it is uploaded, AI will go and pick from there. So we just need to work on the authentication and ethical considerations. Then I come to HASFA. HASFA mentioned, I'll just refer to us to HASFA and the colleagues here. There is an article we jointly authored with the Mr. Aziz Chitaka here. The dangers of using AI while drafting court documents. You can Google it, it is there. Dangers of using AI while drafting court documents. It will help answer HASFA. I'll just cite for you a case we quoted in that article. That is Ainde against London Borough of Haringa, a case which was decided this year, 2025. In that decision, the court was of the view that the president of the King's Bench Division made the following observations on the use of AI during legal research by lawyers and advocates, and I quote, "In the context of legal research, the risks of using artificial intelligence are now well known. Such tools can produce apparently coherent and plausible responses to prompts. But those coherent and plausible responses may turn out to be entirely incorrect. The responses may make confident assertions that are simply untrue. They may cite sources that do not exist. They may purport to quote passages from a genuine source that do not appear in that source. Those who use artificial intelligence to conduct legal research, notwithstanding these risks, have a professional duty to check the accuracy of such research by reference to authoritative sources before using it in the course of their professional work, to advise clients or before a court, for example. Now, summing it up, AI has not come to replace your natural intelligence. Actually, it is humans that generate AI, not the other way, what? Round. What we need is that don't sell your brain to AI. And now once I'm doing legal research, I've got something from AI, that is it. You need to do some more due diligence to first of all establish the source, the authenticity of that source the AI is giving you, to confirm that it is what? Correct. What Austin is using is an example. He's getting these cases from URI, and he's giving you a search tool to go to URI and verify whether that case does exactly exist, and verify the citation and everything that the case has. That is not what AI should only do. You should also what? Do yourself to verify. And those are part of the ethical what? Considerations we are using. So you can look at that article. It has a lot to guide in that direction. Then Geoffrey, what specific changes to curriculum should we do to the curriculum to embrace technology? Those are quite many, and as Dr. Sadat was talking about here, they need a national dialogue. And once we go into that dialogue, there is a lot we can talk about on curriculum review. To at least have the basics we can start on as you join what? Practice. You have those basics. Others you can learn on the job. Today, all of us, when we are being trained in law school, we are not groomed in ICT and the law. But we are doing it because of course, like a gentleman mentioned here. Yes, he's saying URSB has gone digital. How has he used it? This is not his lecturer who taught. He has been teaching himself, learning on the job. Even lands is soon going purely digital. Today you can conduct a search digitally. Do you need a class? So some you can teach yourselves, others need also training so that you can embrace what? Properly. So we can have a discussion to determine what we can have in law schools that can give us at least the what? The basics to start on. Lastly, the question from Alexander, which was on decolonizing algorithms. I think this goes back to the data in saturation. How authentic is this what? Data. So that if we are picking from this data, we are sure we are picking from the right what? Sources. And this goes to create another layer. For instance, when it comes to case reporting, we have the official Uganda law reports, which I work for, and we have other law reports. They have editorial boards that authenticate decisions that are what? Reported. How do we get their products and digitize it so that AI can pick from such what? Products. That's the discussion we should be having. How do we integrate such products that are peer-reviewed, journals authored and properly peer-reviewed? That would be a good resource to pick in. So how do we have that data digitized and in saturation so that AI can come into, and that goes into also another area, subscription. We need trusted AI platforms that we can subscribe to, and we are sure of the sources so that if you give misleading sources, you are even liable. Like if Austin's platform is authenticated and people can subscribe to it, Austin will take liability when we get hallucinated information, because we are relying on his platform and we have paid a cost to use it. So Austin will have a lot of care on the information he's what? Storing for us, that it is what? Authentic. Lastly, Chair, a bigger discussion should move forward to have NITA Uganda, to have the Data Protection Office, the regulators, and also other players in government, because our discussion today has been limited, but there are serious challenges like power outage. Can we talk about AI in areas where there is even no power? Are they going even where there is no internet coverage? Can we talk about that? Maybe Chair will organize a discussion in the future for those other areas.
Thank you very much, Paul. I think it deserves a mighty hand clap. And that almost brings us to the end of this discussion. But before we close up, I'm going to be having the closing question, and it's going to be 1 minute. And I will start with you, Dr. Adeyemo. Doctor, if you were the Director, National Council for Higher Education of Uganda, what is that one thing you will recommend to be done by universities to re-engineer our legal education in this digital era? That one thing.
Okay. That I'm the Director of Legal Education, I will recommend of a curriculum of the university. They must be added as well as the things which promote the curriculum, so that it will be on the students.
Thank you very much, Doctor. I would recommend that we make AI and data management a compulsory course in legal training. And I will now move to Dr. Chisubi. Dr. Chisubi, if you woke up one day and now you are the director of the Law Development Center, what is that change you will make at the center to re-engineer our legal education for the...
Thank you, moderator. Thank you for that question. Actually, it is addressing what I really wanted to say before. My colleague, Dr. Mkili, said, at LDC, they are training the practical part. And my recommendation is that since they deal with the core course unit, earlier on, Professor Mbazira said, the core course units are many. We cannot add another course unit. So my recommendation is we include technology in pedagogy. Is the methods of teaching. How we teach these legal course units. We make it a requirement that there is a practical aspect. Earlier on when I was communicating, I was saying that the lower curriculums have changed. It's now competence-based learning. We need to produce students products that are competent out in the field. So practical aspect, which is tech, the use of technology, is what I will introduce at LDC. Thank you.
Thank you very, very much. This question, earlier alone had reserved it for Professor Mbazira, but I realize it's conflicted. So I am going to throw it to Paul Muchibi. Paul Muchibi, I have been with you in a number of sessions, and one of your lamentations is how Law Council, the governing body for lawyers, works. If you were the chairperson of Law Council, what is that one thing you would recommend to be done as a way of re-engineering our legal education for the new digital era? Over to you, Paul.
Thank you, Chair. The answer is simple. One, curriculum review. And the curriculum review would require embracing digital technologies. Secondly, I would change the law council processes from being manual to digital. All law council processes are still manual. You cannot preach what you are not practicing. So I will change the processes, for instance, application for enrollment to be digital. Even disciplinary hearings of lawyers, they can be digital. So I will ensure that law council processes turn from the manual environment to a digital environment. And by doing so, it will be a very clear signal to those you regulate that we are changing and embracing technology. They will easily cope up.
Thank you very, very much, Paul. Now this goes to Professor Mbazira. Professor Mbazira, the law schools are saying we will make these changes to ensure we adopt dictation, to ensure that we make changes, we re-engineer our education. And the Law Council is saying we will make these changes. And the Law Development Center, the bar, is saying, well, we will make some of these courses compulsory. If tomorrow you woke up and you are the head of the Judicial Service Commission that appoints judges, what is that one thing you are going to look for before making your recommendation for the person to be appointed to the post of a judge of the High Court of Uganda?
It's a hard one. Of course, the tempting answer is to say
hard ones are reserved for professors.
Yeah, the tempting answer is to say that such a person should have gone through courses that are relevant to digitization and use of technology. But that may be unfair because of the generational thing, because technology is also generational. But I think what I would look for in that person is flexibility, whether the person is flexible enough to adapt to the new technologies that emerge, just as Council Paul has shared with us. When the judiciary introduced ICMIS, there were so many judges, just as he said, that had not touched computers, but because of flexibility, ICMIS is actually working. It may have hitches here and there, but it's working because of flexibility. Why? Because the people who were at the forefront of driving it were flexible. So I would look for flexibility, because if somebody is not flexible, they cannot be taught new things. But if a person is flexible, even when they were not taught those things in law school, they will be able to quickly adapt and learn on the job.
Thank you very much, ladies and gentlemen. Unfortunately, I'm not giving my friend Muhammad Shadat Semakula, Deputy Dean of Law, Utamu. He made his recommendations and proposals, which we hope to build on. And I will now we have some 2 gifts for the students. And these 2 gifts will come with a question. So that one who will be able to first give us the right answer should be able to get the gift. And I think Aziz should be able to prepare our gifts. Okay. This one will go to be an open question. As a student of law who is participating in clinical legal education, how would you use the available tools in collecting data without compromising the ethics of the participants. Maybe let me rephrase the question. As a student of continuing legal education, how would you minimize compromising confidentiality of your participants in a research during the collection of the data? Yes.
Thank you very much.
The name and the university?
My name is Watua William, and from Kampala International University. So, first of all, AI, I'll begin by saying that AI can generate, they generate questions of why, how, but then as a lawyer, you have to critically analyze and critically phrase your questions or your answers on how you're going to research. But as to me, if I'm to use, I would just do what has brought me to use those gadgets. How? If I'm searching for something, I'm not supposed to get the very information there. For example, if maybe I am making research on a certain case, what I have to do is to just get the knowledge, not to use exactly what they have used. Me, the part of critical thinking remains part of me because I'm a lawyer. I'm not supposed to use the knowledge from AI of why and how questions to generate for me, and it will stop my critical thinking, or it will shorten my term of thinking. So what I would just do is to just borrow little and use my knowledge of the books I'm reading to critically generate my own understanding of something that is being needed.
Okay, fair trial. I don't know whether Professor Mbazira of clinic education is convinced, but nevertheless, you'll get your gift. One wants to give us a different opinion? Okay. Can we have a lady who, for a different opinion? The question is, how would you ensure that the confidentiality of the data you are picking for your participants is not compromised?
Thank you so much for that question. Well, how I would ensure that, first of all, we have to make sure that we have acknowledged the rightful sources from which you've gotten that information from. And where it's maybe a situation where you have to seek consent, you take the responsibility of seeking the consent to acknowledge them. Thereby, you will not show that it's by your own making. You will have actually given, credit to the person who is worth of it. And you as a person, you would show your understanding. You would add your evaluation of it and your more ideas for its development, rather than showing that it started from you. I don't know if that's making sense. Well,
that will take us to another question. I think the deans of laws of schools, you have been able to appreciate our students when it comes to data protection and so on. I think I will phrase another question, and I would want to Professor to make a comment on the previous question. We will give out the gift definitely. We have the National Data Protection Policy, and I expect that at our level now as students, those are some of the areas that you should be interested in. And it clearly gives guidelines on how you deal with data you pick, how you collect it, how you keep it. For example, how is consent if you are picking data from people, And after you have gotten the data, how is the data kept? So those are very, very key issues that you need to pay attention to. And why I'm posing this question is that some of you are in your third year, some of you are in your fourth year, and the professors here are sending you to the field. And now it's not like our time where you would pick data and use it as you wish. Now the laws are in place. Just recently in Kenya, Meta, which is you call Facebook, was dragged to court for taking data unethically. And you know what? They had to be, they were charged, I think, $9.3 million US. Yeah. In Nigeria, TikTok has been, was dragged to court, and the issue was they were taking data from underage people below 18 years without consent. So the issue of confidentiality on how data is collected is really, really very important. So the couple who got the lady, I think she had a better trial. You'll agree with me. The next question will be, how do you use research tools in your data, in your research, without, how do you use research tools in doing research without compromising your ethical duty in academic research? I think he was the first to raise a question, to raise his answer. So please, over to you.
Thank you so much, Chairman. My name is Kamejo Jesse. I'm a student of Uganda Christian University, Kampala campus. In regards to that question, I think it goes back, because it is in reference to tools, it goes back in how you have trained yourself to actually use these tools, because most of the times, if you are to use certain tools in research, it means you must have the knowledge and the literacy actually to apply the applicability to make sure your research is valid and it's going to be resourceful enough. So I think in regards to that, it's more important for someone to get the better training in regards to using such tools. Because as my colleagues have already said when the discussion started, that actually AI and all the tools of technology, actually we must embrace that. Actually training is the first thing that actually we must embrace before even we look at the bigger picture of how they are being, of how technology is being applied. Are we really getting enough training from the institutions, from our colleagues, and from the different centers that actually are supposed to train us to use these different tools? Because if you have the knowledge on how to apply, it means actually you know how to use these tools in order not to affect your ethics as a person. So I believe that is the right approach I would take. Yes.
Thank you very much. Any other approach? I'm now going to pick a backbencher. Very, very last. Yes.
Thank you very much. For the record, my name is... Thank you very much. For the record, my name is Edmond Humuna. I'm a fourth year law student at Mackay University. First, I would appreciate your invitation to attend this event. Much thanks go to our president who also extended the invitation. To answer your question, one way through which I can try not to compromise data collection methods is through acknowledging the source. That's one way. And then securing the identities of some of the participants in this data collection. Because, for example, if you are collecting data in regards to teenage pregnancies in an area maybe far in Usoga, let's say local district, and you're interviewing maybe let's say young girls, I think it's paramount that you secure the identity of these young girls so as not to be I should say compromise. I don't know the other. Thank you very much.
Okay, good trial. Let me have the gentleman with his specs.
Thank you very much. My name is John Benjamin Namara, and I'm a fourth-year student at Makerere University. Basically, I would do three things. I would cite all my sources, I would go ahead and verify my sources, and I would credit my sources. Simple.
Thank you very much. I think we have the best answer there, in my honest opinion, because that's what the professors have been telling you. Acknowledge your sources, verify your sources. That is it. The rest of you have been doing what Paul has been calling hallucinating. Yeah, you move from here, you go and that side, and so I will take the pleasure to ask Professor Mbazira and Dr. Ademeyo and to come front and hand over the gifts to the best participants. Ladies and gentlemen, this brings us to the end of our conversation tonight, and we look forward to these similar conversations next Thursday. We'll be communicating to you the next topic for next Thursday. And moving forward, we also hope that this conversation can be extended further as recommended by this esteemed team. And the next conversation will involve NITA. The next conversation will involve National Council for Education. The next conversation will equally involve the Law Council. The next conversation will also involve Ministry of ICT. We also intend to have members from Ministry of Education so that we have this discussion from in a broader perspective. But as a starting point, this team here is going to come up with a white paper that is going to be a guiding document for the next conversation. And I pray that members, when you're approached for your input, you don't turn us down. Thank you very much for coming. And let us take this opportunity now to do the usual handover of our certificates and gifts to our esteemed guests. And to the students of law in your various universities, thank you very much for coming, and I think you deserve a hand clap. And also thank you very much for those very pertinent questions. It's the time now when you ask. You know, I was very impressed when somebody says, we are adapting, but are you? So it's a really it was a very healthy conversation. And for the panelists, thank you very much for honoring the invitation. The journey of 1,000 miles starts with the first step, and I think we have taken the first step, and I'm hopeful that this first step is going to be the stepping stone in transforming legal education in this country. I think they deserve a hand clap. And therefore, let me take the opportunity to do the honors of handing over our humble gifts, and then thereafter we'll take photos, and then we can also take a general photo which we can always share with you. I also advise you and encourage you to follow our platforms, that is the space which is at LaTeX Dialogues, which is on the flyer, and also my personal X handle, which is at Tony Kire. I also want to take this opportunity now. This is to the advocates here, ladies and gentlemen. Professor Professor Christopher Mbazira is among the candidates that are vying for to represent us to the Judicial Service Commission, and clearly, having listened to him, you really see that there is no better candidate to send to that place than Professor Mbazira. So please, it will be very important to talk to your colleagues and your colleagues talk to your colleagues. You have equally listened to the very, very immeasurable contributions and submissions of Paul. Clearly, the gentleman knows what he is chasing. He has grounded himself in digital issues. He has done a lot of research. He has done a lot of publications. And therefore, it's my humble prayer on behalf of Lego Tech Dialogues to pray that kindly talk to colleagues and let your colleagues talk to colleagues, and we send the right people to the right places. Because if we don't have the right people in the right places, then we are going to have judges who do not know how to actually even type a judgment. And that in itself is not for this digital era, when we are training these young men for the new digital era. Thank you, and thank you very much. I will now call upon the panelists to move in front and receive their certificates of appreciation. Over to you. Thank you.